Doing good. How about y'all?
Good.
I was thinking,
We do too, we move.
Brett, how you doing? You're doing a lot less.
he'd already got it.
They're all excited about and Gregor.
I saw you were right on the street there. I figured as much just by the expressions on Tommy's face. And he was late to a meeting, and that always sends him up. Yeah, well, I didn't realize that. I mean, he told me, I just texted him and said, "You're right." He said, "Yeah, I'm late to a meeting." Well, I understand. Yeah, I know. But I don't get a family discount. Teach them
I got Larry.
Seats are running out, so that's the way I saw it.
Getting in touch with him, getting an estimate, and I
Went from last.
they do that, I know it's expensive.
Spent the weekend.
The second time we
Shadow has one.
65 was leading, he shot 69 Saturday, he shot 63 Sunday. One of the boys shot 61. Even.
The green stuff up there, the real green. They weren't as fast, they were. Rain suit kind of.
Prayer and pledge, please. Father in heaven, we thank you right now for your goodness and your mercy. We bless your holy name because your name is worthy to be honored. We thank you for what you're going to do, what you've done thus far. We ask you right now, Father, to give us the wisdom, the knowledge to do those things which is right. Help us now as we make decisions for all our citizens. We thank you and bless you. And we ask you that you do deal with us. Let us be mindful that we are all citizens of this county and that we will do those things which is right. Help us now, as only you can do and you will do. And we thank you Jesus' name I pray. Amen. I pledge allegiance
to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
For the benefit of those at home and want to hear this meeting, we do have a way for you to hear. This is a special meeting, and our conference line has been set up 217 or 917-900-1022. The access code is 32347 pound sign. This is not a toll-free call or number. You may be subject to your long distance charge according to your long distance plan. Any person, if you want to speak, please dial 5. The moderator will unmute your phone line when it's your turn to speak and notify you by announcing the last 4 digits of your telephone number. Please announce your name and address, and you will be allowed to speak for 3 minutes. Any person wishing to address the board regarding to an agenda item will be given 3 minutes for a comment. A commenter may only speak once, time on each agenda item. With that being said, we will go to our agenda. Do I have a motion?
Motion?
Second.
Motion second, all in favor? Okay. We go to number 4, the board to hold a joint special meeting between the Taylor County and the Taylor Coastal Water and Sewer District. That being said, who would like to go first?
Please, the commission.
Go ahead.
Good afternoon. Ray Curtis. 103 North Jefferson Street, Perry, Florida. I came to be involved with this matter first in 2019 and involved with the Taylor Coastal Water and Sewer District's policies and practices and representing an LLC, a husband and wife called JKS. We worked through those. I kind of got a temporary fix, and then I came to work again or become involved with their practices when my parents purchased a piece of property at the beach. They created an LLC called Fishery Cove LLC.
Speak of, yes, sir.
Yes. And so, just for the audience's edification, that property is 28 acres in total. Well, some of it's marsh. It's about 18 buildable acres. It's got 1 house on it. And so a letter was sent to Taylor Coastal to say, hey, if there was going to be a development plan in place, or if we sought a development order from the county, please confirm that we would be able to get sewer and water connection. Because on the county's future land use map, it says on 14 of the acres, 10 units per acre. And so the response that we got was, no, you can have 1 for the whole property. And so that kind of started the process of looking deeper at it. And so in this whole lengthy process, made a couple of observations along the way that are 30,000 foot view observations. One, why is the rest of the Florida's coastline booming with new construction? I was at a legal conference down south this past week, and every turn you took, there was a crane with trusses going, being put up, something being constructed. Why there, but not at Keaton Beach and the surrounding area? Why does it seem that all we can do is put RVs on lots? Why does Keaton Beach and the surrounding area have large undeveloped parcels of property? And why is the coastal sewer water plant, why has it never even hit 50% capacity? I believe the answer is that the beach area the same. But they have given by denying them sewer or water connections. And one of the big reasons that they claimed is development within the district is not possible at this time due to the restrictions of our funding agreements. And that's Commissioner Diane Carlton from January 28, 2020 from the Taylor Coastal Minutes. So the question is, what are these restrictions that Taylor Coastal is hanging its hat on in order to stop development? And in 2002, when we were looking at getting a sewer plant down there, the DCA, the Department of Community Affairs, had expressed various concerns. And as it was later noted by Taylor Coastal in their November 6, 2005 minutes, it was noted by Taylor Coastal Water and Sewer District that, quote, the Department of Community Affairs in a letter dated May 15, 2002 expressed their concern about development in the coastal high hazard area and further expanded on their concern in a subsequent letter dated February 4, 2004. These concerns flowed into the federal documents as restrictions, end quote. So that was their take on it. It was the DCA that raised the concerns, and so those concerns kind of flowed into or were incorporated in. Now, the language that was in these so-called restrictions in 2002, that was somewhat vague. It said limit connections to referenced areas, the project location, description of existing homes, businesses, developed sites. They currently have septic tanks. Then in 2004, it was amended, and the currently have septic tanks was stricken. And the added was, and the 181 platted single-family housing lots as of July 1, 2003. And then as part of phase 2, the conditions were amended again. And these are in loan applications. So you fill out a loan application and the Taylor Coastal has to say, we agree we're gonna do all these things as a prerequisite for getting funding. 2008, what was stricken was the language that said referenced areas of the project location. And the 181 single-family housing platted lots was stricken. And so the 2008, it read limit connections to existing homes, businesses, and developed sites, and lots in existence as of July 1, 2003. So it's kind of this moving target, or it was changing around. Now, you'll see in subsequent letters that this clinging to 181 lots, that's still been going on as of 2020, even though it was stricken and removed in 2008. Let's back up to 2005. The Board of County Commissioners was excited about development at the beaches area, and they weren't going to be slowed down by the Department of Community Affairs saying, hey, we have concerns, this and that and the other. And so the Board of County Commissioners and Ordinance 2005-13 on November 7, 2005 sought to change the density at Keaton Beach and the surrounding areas from 4 units per acre to 20 units per acre for those in the coastal high hazard area that were served by central sewer and water. Right, so the idea back then was, remember, the coliform, the bacteria in the water from the leaching of septic tanks. So Taylor County said, great, we're gonna get a sewer plant up and running. And once we do that, you're gonna have 20 units per acre density. All right, but the DCA, who gets final approval authority over land use change or changes to the comprehensive plan, they filed a response and filed an administrative challenge. And so the fight went back and forth. And you remember, they were the ones that raised the concern in 2002 and 2004, the flooding condition. So they raised this challenge. It's litigated, and then there's a settlement agreement reached between the DCA and the county and Dr. Hutchins, the late Dr. Hutchins, who happened on the Fish Creek property. They reached a settlement agreement. So think about it. The people that raised the concern that went as so-called restrictions into the loan documents, they settled their problem with Taylor County in 2007. The settlement agreement that was entered into by the county and the state said that density would be 12 units per acre when served by community or public water and sanitary sewer systems. And when a sanitary sewer system with an adequate capacity is available to the development, available defined as in 1/4 mile of the development, all residential, commercial, recreational, and public buildings shall connect to both water and sanitary sewer. So that's the agreement signed with the state of Florida. Basically, DCA's concerns were resolved by the settlement agreement. Now, the DCA in 2007, or not the DCA, I'm sorry, the USDA, which is the lender that supposedly has these conditions that Taylor Coastal said they were afraid are going to be defaulted on if these so-called conditions are breached. They sent a letter to the Taylor County Sewer and Water District in 2007 saying they were, quote, not going to police the district's actions as they relate to the conditions. And that is from the February 22nd, 2007 Taylor Coastal Water and Sewer District meeting. In fact, in 2006, the Taylor Coastal Board actually formulated 2 policies for development. And those policies were connect individuals and small developments in the phase 1 coverage area as long as they had capacity. Now, in 2009, the Board of County Commissioners and Dr. Hutchins realized that even though Dr. Hutchins was a signer on the first agreement, somehow the legal description of this property had been left off. And I'm looking at Mr. Bishop here because he was part of that, and I think he would confirm that. Is that right?
That's right.
It was left off, so the county passed an ordinance as to his property and a couple around there that felt that they'd been incidentally or accidentally left off, and wanted to basically group them in with the settlement agreement that had happened in 07. So the county was saying these also should be 12 units per acre. And of course, the DCA, the Department of Community Affairs, said, oh, no. And so they filed an administrative challenge to that. And it gets duked out and it gets duked out. But like the last time, there was a settlement agreement reached. And that was in 2011. In that agreement, there were a couple things interesting that were noted. First, in the beginning portion, it said the sites are located outside of the community service areas, community sewer service areas. So at that time, there was not part of an expansion plan to go to the Fish Creek and Bird Island areas. It was only, phase 2 only went to Dark Island, Cedar Island. And so it was noted in the settlement agreement that these sites, Fish Creek and Bird Island, were outside of the sewer service areas, the ones that were planned. And said septic tanks cannot be permitted under the Department of Health rules at those densities. Right? And then we get to the part of what the agreement was, and so the county and the state agreed until such time as centralized sewer is provided to the parcels, the maximum allowable density will be 4 units per acre. Upon connecting to a centralized sewer system, a maximum 10 dwelling units per acre shall be permissible on the parcels. Right? So it was well known. They are not in the planned area, but if you can plan it and build it out to it, then it will go, and on those properties, 10 units per acre. So that agreement gets signed in 2011. Then there was an amendment to phase 2 called phase 2 part 2, where Fish Creek and Bird Island were added into the plans. Taylor Coastal pursued that amendment, got the amendment, and USDA approved the amendment. And then in 2013, the USDA gave its final approval to actually begin construction. So 2 years after this agreement, that very clearly shows what's going on. Hey, there's no sewer here, but if you build it out, then you can go to 10 units per acre. After that, USDA green lights an amendment to expand that area, and then gives a final approval for construction. It seems pretty clear the USDA was aware of the DCA's concerns going all the way back to 2002, and that the USDA approved running sewer to all the coastal high hazard areas, knowing it was going to be 12 units per acre. And then it's really, really obvious that they knew that it was going to be 10 units per acre on Fish Creek and Bird Island, given the way that that agreement was written, and then that they approved the amendment and the final construction 2 years later. However, to this day, Taylor Coastal Water and Sewer District ignores these agreements and their implications. They are choosing single sentences from letters from 2002, 2004, and 2005 that have vagaries like, this cannot be used to support development, this funding for this plant can't be used to support development, things like that. And ignoring all the stuff that came afterward, it clearly shows the USDA approved amendments and changes knowing that there would be higher densities. It's ironically that Taylor Coastal has lamented the growth of the use of RVs down in the beaches area, when they're the ones that pretty well single-handedly have stamped out development. Just since June of 2019, Taylor Coastal has impeded or outright denied development on approximately 60 acres in the Keaton Beach area, costing the community and the county untold amounts of money. Some of those people that were impeded or denied were David Cassidy, Bishop Clark, JKSW LLC, Four Rivers, CR Farm LLC, Cindy Simpson, Sandy Beach, Benji Tootin, Robert Lynn, George Collins, Johnny Price, Fish Creek Co. LLC, David Dahl, Tony Brown, and Lisa Boswell. All people in that area that have either been told that they could have less than the density that you approved in a litigation agreement, or that they could have no water and sewer whatsoever. To the point of intentionally trying to stifle development. There were two prior Taylor Coastal policies, 2005-01 and 2006-03. 2005-01 was called Water Hookups for Newly Developed Lots. And 2006-03 was called Future Phase 1 Sewer Hookups for Individuals and Small Developments. But these policies were in place since 05 and 06. In early 2020, February of 2020, when Taylor Coastal realized that they had pro-development policies on their books, they went and abolished them. On March the 24th of this year, one commissioner of Taylor Coastal Sewer and Water raised to staff that the letters that were being cited to for reasons to deny sewer water connections were from 2005 and before, and that Taylor Coastal's own mission statement in 2006. And so this board member said, I think that would supersede these prior letters. And the specific portion of the mission statement said, Taylor Coastal was to plan for current and future development and monitor and control all new developments to make sure they're in compliance with state and federal regulations and meet or exceed Taylor Coastal's mission statement, quote. That was their mission statement.
Go ahead.
All right. So that's pointed out on March 24th. At the very next Taylor Coastal meeting, April 27th of 2021, Commissioner Diane Carlton raises the issue, states, at least according to their minutes, that the mission statement seemed to be out of date, and so the board voted to abolish their own mission statement. With one dissenting vote, David Dahl. It seems pretty clear that the current board and staff want to take an anti-development policy or approach. And if they find something on their books or in their policies that opposes that, they will outright abolish it quickly. And they'll continue to deny people requests for water and sewer and create rules like one connection per parcel number or various other rules. The big issue I take with this is the Board of County Commissioners, they are the land use planners of the county, of all 67 counties. The buck starts and stops here with only the state level to make sure they agree that it's in line with your comprehensive plan. A sewer company should receive a development order from the county planning and zoning board or from the county building director that says, we've looked at the setbacks and everything else. We approve this plan to build a 4-unit condo. The sewer company should then see a copy of that and say, we have capacity, you are within our zone, we will facilitate connection. That's it. Their job should be really simple. Give you clean water, process your waste. That's it. And then follow the county's land use planning and decisions about whether or not you can construct a building. When you look at the minutes, every month, the board is taking up, this person's requesting if they can have 2 grinder pumps or this, and they're making decisions based on their interpretation of things, when really those decisions are supposed to be made at this level by your planning and building department. And they're supposed to just hook up. But they want to stand by this concept that it's going to violate the loan conditions as if it's going to cause a default, as if USDA is going to come in and foreclose on a sewer district and shut everybody's sewer and water off. I don't think anybody believes that would happen. Or they want to claim it's going to endanger our future funding sources. I don't think so, but neither side has a crystal ball on that. I do know there are people in the audience that are actively communicating with governmental agencies so that when it is time to expand the plant, the agencies are ready to go. So I don't think that's going to be too much of an issue. Adding insult to injury to this whole situation, though, is that the BOCC or its staff have requested 2 prior meetings to raise some of these issues, to ask questions about it, and have been declined. And then at tonight's meeting, there were questions and requests for documents that were provided to Taylor Coastal requesting a response. And as of July 6, 2021, staff member Lynette Center said we do not have any documents that we'll be submitting at this time, save 1 letter from their attorney, and I believe he is in the audience here today. So as to the questions that you wanted, or the questions raised about, well, when you told us in 2019 that there was an automatic mandate to expand the facility if we hit 50%, what document are you basing that on? Questions like that. You didn't get a response to that. So in my book, that's 3 for 3. It's my position, and a lot of folks in this audience position, and a lot more people that are tuning in either on phone or Facebook Live, that it's time for a fresh start with this board. The Taylor Coastal Board needs to understand their dependent special district under the county commission. When you guys pass land use decisions, they are to follow. Especially when you enter into a litigation agreement, where their breach of that agreement could cause the state of Florida to come back and open up the case on you. It definitely should be following that. And that set forward certain densities, certain requirements. When sewer and water were there, they are there. And so what I'm asking the board to consider tonight is that you vote to remove the entire Taylor Coastal Board, except for Mr. David Dahl. He is a recent appointee and has taken the opposite view on these issues that I've been talking about. From my view, a more commonsensical approach. And as you see, he pointed out the mission statement, which then was turned around and abolished next month. I would then suggest that you receive applications and appoint new Taylor Coastal Board members that will commit as a condition of their appointment to abiding by the county's land use decisions, development orders, and litigation agreements, including specifically the 2007 and 2011 agreements. And then have the county administrator send a letter to all the people that were denied in the past, say, 2 years, that were denied sewer or water or otherwise impeded, saying that a new board is being installed and that they should bring their request back to the new board, or something along those lines. And then if the board does that, then there will be a couple of cleanup matters that I'll be suggesting relative to the exemption ordinance that was passed last year. If you recall, that exemption ordinance allowed people to petition to be exempt from the county's code that would have otherwise required connection to the sewer system. But as you've seen in the litigation agreement, county signed on to an agreement where it's free because people have to be mandated to connect. So if you get a new board, it fixes the problem, the anti-development problem, and it makes it where people aren't having to seek exemptions. They are going there and saying, I have approved development permit from the county, you have capacity, let's get some connection going. So I'd be happy to take any questions or sit down for the other side of the speaker.
Okay. We'll hear from the other side. Okay. Thank you.
Good evening, everyone. My name is J.D. Durant. I'm out of Tallahassee, and after my law partner died unexpectedly in early January, I took over representation of the Coastal Sewer and Water District. And I think that it's very unfortunate that the district has been painted as anti-development or pro-development, for that matter. The district knows that development decisions or community-wide decisions that rest with this board. If the board wants to see development, whether it's of the South Florida cranes lining the street type or any other type, that's not its role. And when it has declined Mr. Curtis's parents' request and others, it wasn't because they were for development or only for a certain type of development. It's because the funding restrictions exist as a condition of having received the money from the federal government to build the infrastructure that's out there. I think some of the earlier presentations to this commission may have glossed over the nature of some of these funding restrictions. I was able to review briefly the letter that Mr. Curtis sent. I received it this morning. He may have sent it yesterday. That acknowledged that some of those restrictions do exist, and I think essentially argues that, well, more than a decade ago, someone at USDA said, well, we're going to rely on you to police that stuff. And so, therefore, I guess we don't have to follow the rules. And I'm not quite sure how you get from one step to the conclusion. But there are series of letters that were signed as a condition of accepting the funds that say what the coastal sewer water system, who it can be used and how it taps into new developments. One of them references a specific number of platted lots, and the last in the sequence just says it's only available for existing developed sites. I don't think that's especially vague. If developed sites means anything, it would have to exclude new subdivisions that operate to take one parcel and create many multiples of one parcel. And so I suppose there could be instances where a particular applicant may have a factual situation that operates in the gray area, but new development is, I think, quite clearly prohibited under the funding restrictions. Again, this isn't the district's decision. This isn't this body's decision. This was the decision that was made at the time that the federal government funded the facilities. These were the conditions that existed at that time. And I don't think that the litigation with the state agency and a predecessor in ownership of property out there in this county does anything to change that. Because in essence, the structure of that was a challenge to the comp plan, countywide comp plan, where DCA, who at that time had a more involved role in reviewing local government land use decisions, filed a challenge saying, we think portions of this comp plan are inconsistent with state law for these reasons. And you can even see it in the agreement. The pages, at least the version I got, the pages were a little out of order, but it's all in there in an exhibit with 10 or 15 references to various rules that the state believed were out of compliance. The settlement agreement, all the settlement agreement does is says you modify the comp plan in this way, and if that's adopted by the local government, then the state will no longer take the position that the comp plan is out of compliance. The USDA wasn't a party to that agreement. It's possible that somebody told the federal government about it along the way, but I don't know that. I haven't seen any particular correspondence about that. But the agreement itself has the provision that, hey, you can get this density if you can connect to a public water and sewer system. Which just brings us right back to the initial question of whether this type of development would be permitted. There's nothing in the agreement that tells me that it was intended to override or somehow modify the funding agreement's conditions. It's also not clear to me how that could happen without all the parties to those funding agreements joining in and agreeing to the modification. And so my conclusion, without much hesitation, is that the funding conditions still exist in their present form. And while it may be true that the federal government would be unlikely to declare a default or seek any remedies, as the board, as the district's council, I don't weigh those types of certainties. If specifically asked, in some cases I might, but when I see a clear violation of contractual obligations, or in this case, loan agreement with the federal government obligations on the horizon, perhaps it's my cautious nature, but I recommend caution. This is the legal advice that my predecessor gave to the district, and it seems to have been the same conclusion that the district has reached for many, many years before I came on the scene, and likely before all of the present board members came on the scene. There were minutes that I haven't seen the packet for today's meeting, but I believe that what's in there includes some minutes of the two district meetings from 2005, 2006, and one joint workshop between the district and this body, where this problem was acknowledged, and the consensus, at least among the district, as reflected in the district's meeting minutes, where we need to seek a political solution to this. The notes at that time were talking about reaching out to then Representative Boyd to see if he would be able to help find a solution to get the USDA to relax those restrictions, or to at least carve out some exceptions, something. The district more recently as last year, I believe, could have been 2019, but recently, wrote a letter to the USDA outlining some of the frustrations that citizens have had when confronting their desire to make use of their property, and the restrictions and septic tank regulations sort of providing challenges. My firm wrote a letter to the USDA more recently. I think that this was in late 2020. This is when my partner was still handling the legal matters. And so far as I know, nobody's responded. So the district is not unsympathetic to Mr. Curtis's clients and to others who would like to, consistent with the county's land use and zoning regulations, make use of their property out there, but they have not been willing to do so with the knowledge that granting these requests would put the district outside of the loan covenants requirements, jeopardize the existing relationship with the USDA regarding these facilities, and certainly jeopardize any future funding requests for expanding the system along those lines. I think much of the other things that were presented in Mr. Curtis's written materials and in his presentation to the board today are really not pertinent to the legal issues here. What the board did and didn't do, for all of the different people that filed applications that were denied. I don't know if it was the same issue and all these other ones, and I don't think it matters. If they made a mistake or had a different practice 10 years ago, it wouldn't change my conclusion about what these funding restrictions require as it relates to at least Mr. Curtis's clients. And it doesn't change my conclusion that the litigation regarding the comp plan that resulted in the settlement agreement didn't disturb or modify the loan other thing I would say, is the relief that Mr. Curtis seeks is extraordinary. And you've got, board members, say perhaps Mr. Dahl, that, volunteered for this position and have happily, maybe not always happily, but nevertheless willingly, given their time to the district to address the needs of the customers that are all citizens of this community. And of course, it's the lawyer's role to zealously advocate for his client. And I suppose if my parents were my clients, I might do it even more zealously. And that's fine. There's a lot of room for that in our system. But the district isn't trying to pick sides in that particular fight or in a larger political conversation of what type of development is best for this community. It's just doing its level best, each board member, to carry out its charge. And for better or worse, that includes the restrictions in the loan covenants. And if this commission did take what I think would be an extraordinary step of removing all or most of the district's volunteer board members, the board members that come back are going to have to confront the same legal situation, the same rules and regulations that exist right now. And they might do so with the confidence that this board is given, or this commission, pardon me, has given a clear vote that Mr. Curtis's clients are to get what they want. But that's not going to make it any less risky from a legal liability perspective, in my opinion. I did not go through and try to answer, I don't know if it was included in an earlier agenda, and then somebody emailed me a copy, a list of questions that read like an outline for somebody's cross-examination. I didn't really want to come here and get cross-examined, so I didn't prepare responses to all of the questions and thoughts in there, other than to the extent I already have. But I am happy to answer any questions that any of the commissioners have. The board is here. All the board members are here. All but one of the board members are here, and there certainly could be some things that are outside of my knowledge base, but it was my hope today that we could, if nothing else, impress upon the commission that the district's not the enemy of Mr. Curtis or his clients, or this commission, or anyone else in the community, whatever they're feeling on development in Taylor County. Thank you.
I'm certainly disappointed that you didn't come prepared today to answer these questions. These are important questions that we want answers to. So.
Madam Commissioner, I am happy to answer any questions you have. I did not prepare any responses to Mr. Curtis'
I want all
questions.
these questions answered.
All right, which one would you like me to try to answer first? Which one would you like me to try to answer first?
First question that he's got.
I didn't memorize the questions. I apologize.
Copy of that.
Causing the county to breach agreements, am I on the right page?
Yes. The questions that he's outlined, yes.
And Mr. Chairman, forgive me, I'm not sure what the protocol is, but
Okay.
the chair's preference for me to continue a dialogue with.
We all here, if you all say. You want to let him continue? Go ahead.
I just know I don't have the floor unless
Okay,
somebody
yeah.
gives it to me.
Okay.
So question one. Limiting properties to sewer connections less than those density limitations set forth in the 2007 and 2011 litigation agreement that the county entered into with the state. It would seem, this isn't even, okay, it would seem that the district is causing the county to be in breach of those agreements. Do you disagree? Yes. If so, do you disagree? Why do you disagree, and on what legal authority do you base your disagreement? I think I outlined all of that earlier, where I don't think that what the district is doing is in violation of the agreements at all, because all the litigation agreement did was acknowledge that if certain changes were made to the comprehensive plan, that the comprehensive plan would be in violation. But the comprehensive plan and the agreement requires that to achieve the density outlined therein, that you would have to have a connection to a public sewer hookup. That connection, in turn, the ability to connect to the coastal water district's sewer system is limited by the funding documents. And so it wouldn't be possible for a denial in that context to either conflict or not conflict with the agreement. It would be lines only would be relevant.
Okay, I hear you say you wasn't prepared to answer these questions as written here, but there was several. One question, what about 181 platted lots? Why they're not permitted to be hooked up?
They are.
So as I understand the funding covenant and the particular amendment that referenced that number of lots, is that they are the then existing platted lots were permitted and are permitted to tap into the system. It's newly created lots that are created through development that are prohibited from connection to the sewer system.
Okay, so a 27-acre plot. 1 hookup, 2 hookup, 3 hookup, 4 hookup.
27 acre would be 1 hookup.
Okay, then 180 by 180, how many hookups?
Mr. Commissioner, I think the answer is going to be the same no matter how many hypothetical dimensions you give me. That it's the lots as they existed at that time were allowed and are allowed to hook into the system. And this incidentally is specifically the issue that was flagged when the Water District and maybe others wrote to the USDA to say, you're freezing us in time here. We'd like some flexibility consistent with the overall environmental concerns that may have formed, maybe the reason why we have those restrictions.
But I also think I hear 10 hookups per acre. Where'd that come from? Who was that? Was that Taylor Water Board or was it county commissioners or who?
I think we have two separate things going on. One is, the comprehensive plan and the zoning designations and the zoning of a particular parcel are gonna dictate maximum density. How many units per acre is often how it's phrased, along with the other requirements like setbacks, building on high ground. There are all sorts of things that can limit how many ultimate units. But
To me, some of it doesn't make much sense, but anyway, it's done.
But I haven't seen anything in any of the water management district funding requirements that speaks to density. It all speaks to the binary choice. Yes, you can, no, you can't.
Okay. Any more questions, answers, attorney?
Jumping down, and this may be a question for one of the board members, but, I saw where Mr. Everett at one point had water hookup and was advised that if he didn't tie into sewer, then they would have to disconnect his water connection, and they did, after he advised that, he didn't have any need for sewage hookup. He didn't plan to build a house there, he didn't plan to, park an RV there, he didn't plan to rent the property out, that it was just a piece of property that he was gonna pull the boat up, wash the boat off, clean his fish, done. And he didn't tie into the sewage, so they did cut his water off. it paid its bills for many years, from what I read. And in 2017, they came up. What makes you approve for so many years and all of a sudden you're out?
Well, I guess I don't know that I do approve, Commissioner. This is, one example of the list of grievances that Mr. Curtis collected that aren't related to, new development tie-ins up to the sewer system. I'd have to defer to the board. I think that there is, I don't know if it's a county ordinance or what the source of the district's position that you had to have service on both sides, and when that changed along the way, I apologize, I can't say, but, even if I were to disagree with what the district did in that case, if I were to study it, it wouldn't change my conclusion about whether, newly platted lots at whatever density, can connect to the system given the funding.
This is one instance of, I guess, many, I'm assuming that if this property meets criteria within the guidelines of the district, why? And they're gonna pay their bill, why would they not be able to tie into this, water and sewage?
If I understood the fact pattern that you outlined, it was that the water district said they needed to have both water and sewer. So it wasn't an issue of not being able to tie in. If I understood the question correctly, it was a requirement that you have both water and sewer if you are tied in.
Was that the case all the time?
I don't know. I don't know if that was always the rule or what the source of that rule is.
And the reason the question is, if that was always the policy, then why was there ever a connection at all?
Well, like I said, I don't know. I don't know.
Yeah, I can answer that.
Jim knows.
Years ago, when we first started the water and sewer system down there wasn't no sewer system. It was water only. He hooked his water back up and it wasn't nothing but water. You couldn't get nothing but water. Everybody had a septic tank that wanted to build a house or had to redone a house after the storm of the century. The one with the septic tank could get water, but a lot of people got water that didn't have a septic tank, just to have a fish cleaning table and that kind of thing. I can't understand why they cut his water off neither. I mean, yeah, he was paying his bill, and for all them years, he had water, paid his bill, and I don't know who made that decision on the board at that time, but she making, just answer to that. But I feel like he had that water all them years, he needs to keep that water and keep paying his bills, or as far as I'm concerned. That was wrong.
Being one that meets the criteria within the guidelines to tie into the water sewage, if they want just water, why can't they get just water?
Well, Ms. Centers just handed me a copy of Taylor County Ordinance 2007-05, and section 7 of that says that the owners of all houses, buildings, or properties used for human occupancy, employment, recreation, or other purposes situated within the district's wastewater service area that are required to connect to the district's public wastewater system in accordance with the provisions of this ordinance shall also be required to connect to the district's water system. So that,
He was already connected to the water system, if I understand that right?
For years.
For years.
And then before the sewer system even got there.
so,
So by the policy set by the sewer authority, his service became null and void?
I have, with all due respect, I'm not sure what happened and what didn't happen, but it sounds like the district at that time, whenever this was, made the determination that this was a county ordinance that required hookups both ways, and perhaps that decision could have gone the other way.
There's a person that made that decision. There's a name or names. Who are those people that can make that decision? I mean, if we don't figure out who, we can't fix who did what.
There's one question, Mr. Bishop, is there a county ordinance that mandates such hookups? Did the county set that ordinance?
We have letters that we had to hook up to the
Just a minute.
water system. Because we had well water and we had sewer system when we moved into that house. We had to do.
I'll try to answer the question. The answer is, to your question is yes.
Okay, so a previous Board of County Commissioners
Pass that ordinance.
passed the order.
Yeah.
I see. And we don't have any idea of that year.
2005, I recall.
This particular ordinance that I just read from was 2007, and whether there was a predecessor ordinance or if it's,
Started in 2005.
yeah.
And that is a Taylor Coastal ordinance, not a Taylor County ordinance.
That's not a,
So that's a policy of Taylor Coastal.
Yeah, it was one of our ordinances that we set,
I see.
because we were made aware of the county's ordinance of mandatory hookup. So then they found that out, they went and put that in place. And then we asked Conrad to review that mandatory hookup, and there's a letter I gave to Mr. Durant about that we wrote, then we received a reply from Conrad about whether we could actually turn these people off. And he wrote back and said, yes, within those ordinances, that we were allowed to do that. We could require them, one of two things, they could hook into the sewer system, or we would have to disconnect their water, and we gave them 12 months. There were 25 water-only customers.
I responded to that. There wasn't any specific facts involved in that, but I responded to that. A couple of things with respect to what Mr. Duran has talked about that I would like to respond to at some point.
Then, you got some more questions for him? No. Go ahead.
I don't have a question right now. The only thing is I want to say is that, you know, we've all heard, ones of us that been here for a while, we've heard all kinds of stories about things. People have been here before us with stories, with issues with this board. And so we can't go back now, we can't fix what happened to Mr. Everett and to some other people that have talked to us, but what I'm more interested in is going forward with new development. That's my concern now. What are we gonna do going forward? That's what's important to me. But if Conrad had something to make, I'll let him.
Trying to say something and get through.
I'll yield the floor, absolutely, and I'll be
Please
happy
do.
to answer any other questions if any more come up.
Just a couple of things with regard to Mr. Durant. He presented some documents to Ms. Pemberton, who is our county administrator, and she kindly sent them to me on Thursday of last week. And essentially, there's two letters, one from Mr. I think it's Floyd Ford, if y'all remember. Now, this was from Glenn Center back in 2006, which asks some of the questions that have been raised today. And then there's a letter of 2020 from the late Mr. Boyd to Ms. Ruggles, the area director of Lake City Rural Development Office. But I never saw anything in writing with regard to a response to their questions. It's always been verbal that, and I'll tell you this, sir, that this board asked the, your client to present to Rural Water our questions and also come to the meetings. Your client didn't come to either one of the two meetings that they requested for y'all to come. We appreciate you coming tonight, but they didn't come as a practical matter. And it was kind of an affront to this board that they did not come to the meetings with respect to the questions that numerous people had complaints about the conduct of not issuing permits. And I will tell you this, in my experience, our ordinance and the comprehensive plan is the law of Taylor County. And I was the attorney that went and fought with DCA to get
the, permits, our ability to have those permits we had to fight like crazy to get them to agree to the, prerequisites of the, stipulated agreement, the last stipulated agreement that, Mr. Curtis has alluded to, which, the point being is why would we have that agreement if we're not able to, if this board, who is the planning agency of the county, not able to issue permits for up to the amount that the agreement, stipulated agreement with DCA happened. And, you know, this board has never heard from rural development with respect to what y'all are alluding to. Those are the problems that I have with it.
Happy to shed light on one thing. The USDA has not responded to either the letter sent by the Taylor Coastal Sewer and Water District or the letter that my firm sent in writing, as it relates to my firm, in writing or otherwise. So if we wish we had gotten a response, I certainly have become well aware that that development in this area has been a generational struggle in trying to get us there. I completely agree that in Taylor County, the Taylor County law is the law of the land, and the district, I don't think, has ever done anything in its actions that are inconsistent with either the agreement, the litigation agreement that the USDA wasn't a party to, or the comp plan. But through all of the history and through all of the litigation, those funding restrictions are still out there. I don't know that anybody says otherwise now, except for a lawyer for one party that wants to develop out there has a theory that because of the passage of time, that those restrictions just aren't going to be enforced, so we can ignore them. And that's the only real point of disagreement I believe I have with at least Mr. Curtis's clients. The other people that have had issues with the districts over the years, I'm less familiar with, but I hope that answers the concerns or indirect questions that Mr. Bishop asked.
Well, if I may, the letter from Mr. Boyd was dated August the 20th, 2020, and no response, you know, and that was my point. I would certainly want to get if I was in your shoes, well, I'll tell you how to do your job at all, in this instance, but, I think my client, which is the Board of County Commissioners, would have liked some response from y'all, and from, rural development. Of course, you know, we all know that, for instance, if the rural development says that you violated the agreement and wants to cancel it, there are other funding entities now in America which have really low interest rates.
Mr. Chairman, if I could.
I don't know if that was a suggestion to violate the agreements or.
No, it's a fact. It's a fact, because what we've done in the past, and I know that you've dealt with counties before, counties borrow money from local lending institutions or national institutions, and the interest that is paid on that is tax-free to the lending institution. And that's why you're able to get low rates of interest on loans that municipalities and counties get.
I appreciate that reminder about municipal tax bond rates, and certainly if this was, I think Mr. Bishop was suggesting that the county were to pay off the loans, then the funding covenants would no longer govern any of the hookups.
Mr. Chairman, if I could ask Mr. Grant a couple of questions, and some of those are in respect to the defined limitations that, you got, I believe, and the water and sewer,
or, they did not show up. I believe you said that was done that way because of funding restrictions? Is that what I understood you to say earlier? That's why you advised those guys not to attend those sessions?
No, I don't think any of the decisions related to attending any of the various meetings that have been proposed had to do with the funding restrictions themselves. That didn't govern.
Could you expand on that as to why that is so?
I'm sorry, I don't understand the question.
Question
Why
is-
did they not, why did they not come to the last, which was, I think, a version of this that,
No, sir, it was an effort to try to get some solutions to some of these issues. And so, at a minimum, my expectation was at least we would have seen you
yeah.
or the board, but we saw neither.
Right. Well, what I have knowledge of is that the issue with the funding conditions has been clearly expressed to Mr. Curtis, sometime last year. And he is quite thorough and writes these long missives that require the district's time and then its attorney's time. And when I talked to the district about it, I recommended that there's all that's gonna happen if we go round and round with Mr. Curtis ad nauseum, is that there's gonna be significant legal fees that ultimately are gonna get passed on to the customers. I represent other public bodies, and I'm quite mindful of the ultimate payer of my services. And I didn't think it would be necessary for the district to incur a bunch of legal fees for us to hear an oral version of Mr. Curtis's detailed written letters. I don't think I or the district had the idea that the commission wanted somebody to stand up here and answer questions the way we are today. After the last meeting where there was the presentation geared toward removing the commission the board members, that came through, and so we're here now.
But let me ask another question. You understand that the time is running in the sense of these folks that are seeking the service. And the time that's running is them seeking litigation against the Board of County Commissioners as well as Taylor Coastal Sewer District. So I understand and I can respect the fact that you want to save some money. But at this expense, I don't think it's gonna be saving any money because it's a continuation.
I'm aware.
And it's really not leading to a solution at all. It's leading to a train wreck in some sense. Because of the time factor that these individuals are being subjected to, and now that this board and the taxpayers are gonna be subjected to, if we can't come to a solution. So that in and of itself is why those type of meetings were requested. It wasn't just for another session of having an opportunity to sit down and just speak. It was for a solution to be arrived at.
Well, I understand, I hear you, and we're here now. I'm not sure.
But you're here now
Yeah.
without this completed answer to these questions. And these are very relevant to these situations that this board has to consider, that all parties are involved in. Yet, again, we don't have all the information that we need.
Well, what questions would we like to go to then? Like I
Let's look
said,
at
I
number 10.
didn't
Certainly,
prepare.
we can answer all these questions if we want to get down to a substantive solution.
Okay.
But just in respect to the newly created lots on question number 10, there seems to be inconsistencies as to, I'm sorry, there's only this many services, but there was a handshake made on this. And so, I mean, these are from the Taylor Coastal minutes.
Right, and this is what I referenced earlier with the, collection of prior actions. Some of this stuff, it wouldn't directly implicate the issue with the funding restriction and new developments. Some of it might. But the fact that this was a question before, around the time, 2005 to 2006, that came up in joint meetings with the district and the county commission, and another, at least on the district side and other meetings, demonstrates that this issue's been a question for a long time. And the fact that different compositions of both bodies might have pontificated or, you know, taken action that's varied over the years doesn't, I don't think, end any of our inquiries, just as this commission isn't bound by policies of the earlier commissions. It's free to change the new ordinance, revise new ordinances, revise its policies, procedures. That's also true for the water district, as long as it's consistent with the county's ordinances. So, you know, when you're trying to get a result for your client, you try to beat up the other side as much as you can. That's what Mr. Curtis has done. Maybe there's some merit to it, maybe not. But these questions.
I have a question, can I have some time?
I've tried to answer your question. I'll yield the floor to whoever the chairperson would say, or answer any follow-ups.
Do you mind? Yeah. I talked to Mr. Newman already, but I'm Gail Lundy, I live at 1750 J.L. Gibson Road. I got approved for 20 units on an acre back in 2002, and I got approved by the zoning board. And I could put 56 units there, starting out with 25 units. And Mr. Meisner, Bob Meisner, was on the water board, plus he dealt real close with the Swanee River Management, and he was on the zoning board. And he was an engineer, and he helped me do all my planning, and we went forward with it. And I had to have 2 meetings of the zoning board, and I was approved for all that. For 56 units, we were doing it in phases. I was approved to do it, and then the bottom fell out with the real estate market, so we never moved forward. I never went and got my permits and all that because of the bottom falling out. And y'all know how that happened in 2003, 2004. So then I went back at 2003, got approved for 18 campsites through the zoning board, and I was approved for that. And then we just were never home long enough to do it because we were just on the road working, Henry was working, and we were busy, so we were never around to do it. So anyway, I would come home, we'd be laid off for a couple of months, and we'd call and see if we could get grinders, and they'd be like, yeah, you can get them, and they've been really nice down there. They've always helped me at the water board. I don't have anything against them. And then, about 3 years ago, I talked to Diane before she retired, and she said, yeah, now Gail, they've gone up from like, I think it was $4,000 when we hooked up to ours, and then it went up to, I think, 6,000, 7,000, something like that. Anyway, the last time I called her, it was like 15,000. I said, to what? She said, yeah, 15,000, hook it to a grinder now. And I said, golly. And the man straight across the road from me had just hooked up to one in 2015, okay? And I called her, she retired 3 years ago, I guess. Well, then when I got back to call again, you couldn't get grinders anymore. You had to get a septic tank. But I couldn't do that because I couldn't get any grinders for my children. I can't even let my kids put a house on that. We have 13 acres, 6 of it buildable, and we can't even let our children put a house there with a grinder. And that really bothers me. So that's just, and I wonder because, do I get grandfathered in? They knew growth was allowed me there. I even got studied under the density plan, like the height of our condos and everything. I mean, we did everything to the T, and Bob Meisner was like that. And he dotted his I's and crossed his T's. So I just wish, that we could do growth like you're talking about. So that's just where I stand. Thank you.
Thank you.
And I have a stamp from y'all's office here.
Go ahead, Rick.
Thank you, Mr. Chair. I wanted to briefly touch on just a couple of points. Want to touch on a couple of points raised by Mr. Durant. As to the litigation agreement and the interplay between it and the funding agreement, Mr. Durant asserts that the one is not necessarily correlated to the other, because if funding arrangements don't allow connection, then the sewer connections are not really available. So when the litigation agreement says when it's available, level, Mr. Duran, if I understood him correctly, is saying it's not available if it's prohibited by the funding arrangement. But the litigation agreements actually define and say available is defined as being within 1/4 mile of the existing infrastructure. So the litigation agreement defines what available means. All right, next. As to my opinion on the interpretation of broad stroke terms like developed sites, or can this be used to support development? What does that really mean? I'm not alone in my opinion as far as attorneys go. Part of the, your packet today is a May 14, 2004 letter to the U.S. Department of Agriculture. And it was written by Boyd Ford, the chairman, C.C. Mary Gavin with USDA RD, and Mike Smith. And it says in part, the attached letter reference 2 by Michael S. Smith, our attorney, states in his opinion, this clause does not restrict or prohibit commercial or multifamily development. Mr. Smith cites the Environmental Protection Agency as a source for his interpretation and states that, quote, the remaining platted lots, parens 181 cited in the amended letter of conditions in parens within the district may be developed for the purpose of accommodating both residential and commercial construction. So, and what it was referring to higher in the letter, it said you've done an amendment to the letter of conditions on March 9, 2004. And so this letter is authored to USDA on May 14, 2004. So after the second letter of conditions, and it says our attorney doesn't see it the same way as you. He thinks it can be multifamily, it can be commercial, it can be residential. So Taylor Coastal's own attorney has taken that position in the past. And that position may have changed, but it would explain why you had the 2005, 2006 development ordinances that Taylor Coastal put on the books. But I just want to make that clear. How is the public ever supposed to know what their development rights are? Period. Well, future land use map, because you guys set the rules on that, and that's where we should all be looking when we go to buy a property. Not having to go through thousands of pages of minutes like I've done, and more than thousands of pages of board packages for Taylor Coastal's entire existence to see when their attorney opined this way and when their policy went this way versus when it went this way, and then they did this thing here and they did this thing here. We can't read that. The process is we go to the county, zoning planning, as Lundy was stating, they check out everything and say you are approved to build this or that or the other on there, and you go down, and the only question should be, am I within the service area? Is it available under the litigation agreement within a 1/4 mile of infrastructure? And do you have the capacity available to hook me up? Which, they've got about 500 to 520 residential units worth of capacity available right now. So I'm not alone in my opinion that the language in these letters of conditions were vague at best, and then the fact that they were, in my opinion, impliedly accepted by the USDA, who approved running sewer and water to properties subject to the litigation agreement after the litigation agreement, I think is not as tenuous as may be suggested. Questions about what the USDA would do if there was a violation? Well, Taylor Coastal, correct me if I'm wrong, but last year they reported between 13 and 20 so-called self-reported to the USDA and said, hey, we messed up. We issued connections to these things that in our view would have breached the fund conditions, and so far, zilch. No response, no foreclosure, no default. Frankly, as they've said in prior letters, they don't want to police it. And even when Taylor Coastal self-reports what they believe to be a violation, nothing happens. Lastly, Mr. Durant made the point that Taylor Coastal can make changes to the rules when the question was asked about water and sewer together or newly developed lot splits. That was the one. And Mr. Durant said, well, Taylor Coastal can make ordinances and set policies as long as essentially they don't conflict with county code. But in the context of talking about development and lot splits, anything they do that's not exactly what's in your LDRs or in your comp plan is in conflict with your law that you've set forward. And so if they say, well, if you split this lot, you can't have, you know, however many connections, that basically limits their development. If you split this lot, literally people in this room that have been told, well, you split this acre into 2 half acres, that one can have sewer and water, but that one can't. But what would the county's code say? Mixed use urban, 12 units per acre per the 07 litigation agreement, and you got 2 half acres there. I'm not a math whiz, but I'd say that's 6 on each. But they limit it to 1 on one and 0 on the other. That is in conflict with your lawmaking authority as it comes to land use. Yeah, answer questions if you have any, or I'll sit back down.
I got a question. It is, I believe I've seen this in these documents, but isn't the USDA aware of the density that's on these parcels?
I've not seen a document where anyone communicated it to them. Now, granted, the USDA was involved with Taylor Coastal for the better part, intimately involved for the better part of 8 years between 05, maybe 04 and 2013, when they approved the final construction of Phase 2, Part 2. And so, and everything down to the format of bid documents to be advertised in the newspaper, to construction documents, to engineering documents, everything had to go to USDA for review and approval. So, although I did not see anywhere in there where someone wrote them an email and said, just letting you know, this is 12 units per acre, this is 20, I don't know how you can escape the conclusion that they knew. All they had to do was look at the future land use map. Or be aware of 1 or 2 of the litigation agreements, or read Taylor Coastal's minutes where they talked about the litigation agreements and the change in density, or read the BOCC's minutes where they talked about it. So the fact that I don't have a written communication that shows that they were advised of this, I think should probably hold pretty little weight. If any of us were in a court of law and saying, well, I didn't know there was a defect on the title of this property, the court would say, was it recorded in the public records? If the answer is yes, then the law is you were placed on constructive notice. You had a duty to look and know. That's the standard we would be held to as individuals. So the U.S. government, after being involved intimately for 8+ years with this, I think they got a duty to know what the density is of the property that runs sewer and water, and approving running sewer and water to.
Go ahead.
Okay, I don't have a question, but I just want to say this, that when we inhibit connections and we inhibit growth, and then in turn, that costs the county and it costs businesses money. So in my opinion, I think that we need a board that's more pro-development and more customer friendly, and they don't pick and choose who gets water and sewer services. So if, Mr. Chair, if there's no more discussion, then I'm prepared to make a motion.
Any more questions? Go ahead.
Did I hear y'all say right a while ago that the Board of County Commissioners are the ones that said that Mr. Everett water would be cut off?
That was said, but that was a mistake. The ordinance that was being referenced, 2007-05, was a Taylor Coastal Sewer and Water Ordinance, not a Taylor County Board of Commissioners ordinance.
They're the ones that made that, y'all the one that made that decision.
It was a Taylor Coastal ordinance.
The Taylor County ordinance was a 2005 ordinance. The one I read from was the Taylor.
Ordinance from the board here in
Correct.
2005, they made that decision.
No. The 2005 here was the one that mandated people within the service area to connect to water if water was available, if the infrastructure was available, and then to connect to sewer if the infrastructure was available within the service area. Remember, the service area runs from Fish Creek all the way to Spring Warrior.
That's what I said.
I understood you, but when we're throwing around TCW and TCBOCC and things like that, it can get confusing. I know you know, you were there, you wrote
Oh, I mean, does anybody from the board themselves, would they like to speak to any of these versions?
Yes, sir, I would. My name's Steve Brown, and I've lived in Cedar Island for 21 years, and, there's been a lot of misinformation tonight, all the way around. I know Mr. Curtis is a lawyer, he makes a lot of money, you know, manipulating words. Basically, he's clairvoyant, he knows my every intention, he knows my thoughts, he knows everything I've ever done. It's amazing. I've been on the board 7 or 8 years, and in all that time, I've never can't think of one instance where anyone was against making a logical, informed decision based on the information we had. You know, and as an owner of a house, you know, my property value, you've turned my neighborhood into an RV camp. You know, I've lost a lot of money due to that. That's all right. I don't take that as you intentionally did that to me. But he besmirches all of our character and all of our integrity by the things he throws out in his letters. You know, and since you want these resignations, I came prepared. You can have that. And I love Taylor County, I love the people here. And I always have, I can move. I'm not gonna do that. But I think, you know, you have got a lot of misinformation. The reason we did not show up to the board meeting is when we came, we were completely dismissed. You know, we were treated like one step above morons. You know, you wouldn't listen to them answers. You know, you wouldn't let anybody speak. So, you know, kind of a two-way street. You know, I would expect to be treated with some level of respect. You know, and I think that's, you know, common decorum, and I don't know you individually, and therefore I can make no assumptions about your motivations are. But be aware that there are people out there that are less than happy on the other side. I understand they want development. I really contest his contention that we don't have development because of the water board. Every one of those lots around me could have a house on them. People have chosen not to, why? It's pretty obvious. I can buy a lot, put an RV on there, I pay less taxes, I don't have to pay insurance to speak of, you know, I don't pay for full trash service. It's a great deal. I'm not mad at the people, we got some great people moved in there. But I just feel like a moron because I spent a lot of money building up the code and doing what was expected at the time. And, you know, that's not a good position to be in. So I thank you, and I hope the other board members will not take it personally. We all take a beating.
Anyone else speak? Can we take action tonight?
Yes,
On the special meeting?
I'm prepared to make a motion.
Okay.
Okay, at this time, I'd like to make a motion that we remove the entire TCWSD board except for David Dahl, and that we appoint a new TCWSD board that will commit to, as a condition of their appointment, abiding by the county's land use directions, development orders, and litigation agreements.
It's your motion. I'll get a second.
I'd like to, I mean, I'm not gonna second that motion, but I'd like to, discuss with this board if they're, at a place of commitment so that we can, if it's in order, Mr. Chairman, or Mr. Attorney, I'll take both your directions, but,
Well, first of all, I think that he needs to, declare that they're,
You
okay.
go ahead and pass that to Jim. I'll second that motion.
And then you say all in favor, say
Well,
aye.
yeah.
All in favor, say aye.
Discussion,
Okay.
is there any discussion?
It's right in discussion points, but, did you want to say something, maybe, in discussion? So in discussion, I mean, my question would be to, the board of Taylor Coastal Water and Sewer District. You know, we're obviously at this place of possible dismissal, and so my question to the present, board members is, you know, is there a way that you guys could commit to see through to the job that you've been appointed to? before this goes to vote. Please keep. So nobody's gonna, answer that, I'm ready to move forward, Mr. Chairman. Okay.
So you're gonna call for a vote?
Call for a vote. All in favor?
At this time, I can't vote to do that without giving a little more interest and chance of talking to USDA and getting this thing straightened out completely. I think we're getting sideways with this thing in a hurry. I mean, we need a little more time to think about this. I mean, this thing's been beat around a long time, but really, it just come to us wanting a quick answer on this thing, and it's kind of, I think, as far as I'm concerned, it's just a little too quick, so I'm against it.
Is there a way, is there a way, Mr. Bishop, to get an expedited decision from USDA?
I doubt it. We certainly can request it, for sure.
You know, the district would welcome any assistance in trying to get a quick resolution from the USDA, certainly.
That was proposed to the district in 2019, meeting with the district. That was Mr. Bishop's suggestion. It was brought to their board and they rejected that specifically in their meetings, not to engage with USDA about modifying the restrictions. It's only now that the drumbeat has continued to increase since late 19. This isn't Johnny come lately. It's late 19 with pressure increasing and good council board, all of a sudden, okay, let's send a letter. So meanwhile, members of the public have been waiting to see a change effectively occur. And like Mr. Bishop said, I think also in the Taylor Crystal minutes, there is no expectation of a response anytime or in the near future or ever from USDA.
Discussion.
Go ahead.
Okay, first of all, this is not a spur of the moment decision. This has been going on for years. I've been here for 11 years. There's been serious issues for 11 years. You just asked the question, could anybody commit? You didn't get the first answer. Not the first answer. So I don't see any point in kicking this can down the road and continuing on. Let's get on with the business of appointing a board that's gonna help us with growth and help us, with people that wanna connect and not pick and choose.
As far as I'm concerned, here's the thing. This board has listened to both sides of this situation, but getting in a hurry to just throw the board down, the water and sewer board down, and all but one person, all of a sudden, it's kind of, I mean, that can hadn't been kicked very far. I feel like I need an answer from USDA that there's no way, I mean, what if we did go along with that, Pam, and then they come up and said, well, we're gonna pull our loan from y'all because y'all not following the rules? I mean, what do you think about it, Mr. Conrad? Can they do that? Can they call their loan on it?
I'm sure they can, but of course, there's certainly a defense to that as a practical matter. So, you know, somebody asks me a question, I try to answer it, and, you know, we tried to get them, Mr. Curtis is correct, that we tried to get them to come or to respond to us, and I'd certainly, you know, make a phone call tomorrow. I would certainly send a letter tomorrow, but I can't tell you what they're gonna do, you know, and what if they don't do anything?
Right, well, I'm not against development at all. I built a lot of stuff on the waterfront and done a lot of things down there. And I did it all by the book with permits and everything else. And I had, you know, the blessing of the water and sewer system, but it was only, when I did it, was just a water system. Then near the end, of me building, they ended up with sewer system too, water and sewer. But I'm not against development at all. I'd love to see some new things built down there, and some new things on the tax roll. But I don't wanna get us in a bind where they'll call their loan, and then it puts water and sewer system in a bad situation, you know? I mean, if they do, they do, you know? But I'd hate to see them, you know, I'd hate water and sewer system to be shut down just because of this thing, you know?
Mr. Mayor, if I may, as I understand it, and Ms. Center can probably correct me if I'm wrong, I think there's only around $1 million left on the note, and I've heard that number floated around.
1/7.
1.7, and so, in the event that, they self-reported alleged violations last year and nothing happened, but if for some reason all of a sudden they got interested and decided to do that, doing what Mr. Bishop was saying about defending a foreclosure action, and saying, I'm sorry, this is too vague, you can't foreclose on us, in that time, you could seek out funding agreements for $1.7 million. You got the revenues to cover them, because you're covering them right now. So, the likelihood of a water and sewer shutdown, if that's been put into your mind, is, in my opinion, a fairly hollow scare tactic.
But you don't think they shut them down, what you say?
Even if they tried, you could take a lawyer and defend it in court and slow it down enough until you could get a different loan agreement with somebody else. 1.7 with the amount of revenues they bring in. Yeah.
But who would be paying that lawyer? The taxpayers of Taylor County? And I don't think the tax, as a whole Taylor County taxpayers don't need to be paying for just a small group, you know?
Well, respectfully, you've got a whole bunch of people here that have been cost the ability to develop their properties, and a whole bunch more that didn't show up here. And we're not considering the possibility of sending one lawyer to defend a foreclosure action that's probably never going to happen, as opposed to what these folks over here have already lost. Seems like a pretty tilted scale.
I got a question, I guess, Mr. Bishop. Would it be possible, and this, obviously, if there's somebody on the board that wants to answer to that, is it possible while we seek out that, response from the USDA, that we could see if there were other grant or funding possibilities for development and growth? Such as, I believe the program is sewer to septic, some of those opportunities that wouldn't put the USDA, at the forefront, but would obviously put the option and opportunity to take it on these types of, development situations.
Well, of course, that would be an answer from your grants administrator, on that. But what, Mr. Curtis was saying was that, if they call the loan, then, with regard to the, funds that the water, gets, that it would probably be very simple to get a loan to pay off the 1.7 that's owed to, rural water. I think that's what he was saying. And I had suggested that previously.
We're talking about something that may happen, but we're looking at a lot of people here that something may happen also. So,
Before we do that, I hate to see, I know the people down there that on the water board. My hats off to you, you know, you're doing a lot of services and probably no pay, very little thanks. But I also see people who have made investments in the property down there that need to develop. We don't need to hold them up. It's time now that we have to move. And I know these people over here sitting in a place that I felt all my life. I always felt like I might have been a little bit sham, but I got over that. And I know the only way for me to make it, I got to push forward and forget and do. They act like they want to move, they want to do, and I'm for progress. So I've made that motion, that's that motion. What you call it?
just, I mean, if we could get some sort of time frame, to know there was no response, that would be coming down from USDA, that we had exhausted every option to be able to try to push forward and see these opportunities. And I do understand that, there's a time, a window that's closing, rapidly in some respects. But that's my position at this point.
Why couldn't a new board do that? And we can be moving forward and let the new board do the same.
Why don't we just seek out some funding and get the funding to pay that loan off and be done with it?
The Water Management District has River and Springs program set up by Governor Scott, and they're looking for active customers or partners. And that could have been sought out years ago.
For septic to sewer.
Yeah.
The
Yeah, and that-
larger problem though is dysfunction up until this point. Dysfunction in the interim while that's going on, and lack of trust by a lot of citizenry down there that they'll get a straight answer. For instance, the first place you go when you want to develop down there isn't to the building department here. You're stopping down there to see if they'll even give you sewer or water if you want to do something, even build a house. Single lots have been told no. And so that is backwards. It's supposed to start here. Now, in the meantime, if we wait for a letter that's probably never gonna come, or a lawsuit that's never gonna come, he's got projects in the hopper right now, and was at their last meeting saying, what about this? Well, we're gonna have to talk about it as a board and try to decide whether or not you can have this one, that one, the other. He still doesn't have water in his lot. They have, according to the litigation agreement, 140, the potential for 140 spots. They may not even want to develop it. If they want to borrow money against that value, it's got to be declared first, which we thought the Plum map declared that, but apparently you need sewer and water on board too. We're over here, several projects going on. That's half the room with one arm. While they wait for a letter that Mr. Durant, I believe, has put in a letter, is not likely to come, or at least in the minutes it said Mr. Durant expressed it's not likely to get a response. And that, I think that letter requesting a response was August of last year, is that right? August of last year. So we're almost a year since that letter. We're almost a year since self-declaring alleged violations. Nothing. But these people don't get it.
Ray, can I say that?
It's not my call.
Can I say one thing?
Okay.
The prior property appraiser, Bruce, I asked him about property values of the beaches we were discussing, and we have property down there, and I said, what if we subdivide our property and ask for more sewer hookups, which I understand they're denying now. He said, well, if they deny you, I'll reduce the value back to $100. So you're actually, in effect, the sewer district can actually destroy property values down there and actually lead to more litigation, the reverse of what you're saying. So, you can, it just opens up the can for a lot more litigation than does than what, you're talking about a little bit of litigation in terms of going forward, but if you don't do something, then, it could be getting much worse going down the road.
Yeah, I'll speak. My name's William Uxford. I'm on the board of the Taylor Water and Sewer District. I've been there about 2 years. I know a lot of y'all. Some of you actually came to meetings. Now, Mr. Newman came when he was running for commissioner, Taylor County Commissioner, but he did not come when he was invited to come to one of our meetings to discuss these issues. Don't know Mr. English, Mr. Dempsey, I know, he knows my brother and all that there. But the effort of the board, which includes 4 part-time people, 1 full-time person, we did last year, as I believe Mr. Curtis mentioned, do $186,000 in total revenue. And we saved some, and we have a savings that will help when there will be a disaster, which is not if, it's when. We're gonna have another disaster. The Water and Sewer Board has been preparing for that the whole time of them collecting revenue. I've been there 2 years. I'm a financial guy, have an accounting degree. I watch the books very closely. We can't get any information, financial information about Steinhatchee Water and Sewer to compare to. Mr. Curtis has mentioned that everybody here has been hurt. I will relate to you that the first request from Mr. Michael Lynn came less than a month ago. Our process is set. We have a set process, just like the Board of Commissioners does. You come with the request. It's supposed to have information on it. If it's a multi-unit development, it's supposed to have information on it about the engineering, about the placement of the units, and about the number of units that they want to hook into the water and sewer. Mr. Lynn was told at our meeting on the 22nd of June that we would consider all of his 11 requests and would have an answer for him within a month. This is the same as we treat everybody else. When I started at the Water and Sewer District, one of my requests, and it should be for this Board of Commissioners of Taylor County, to treat everybody equally. That's the only way I was taught. That's what I understand. And that's what I've asked for from my fellow board members with the Water and Sewer District. We have not treated anybody badly. We are following the procedures that have been set up over the 20 years or so that the water's been on. And I think it's, when was the sewer finished?
It was finished in 2011.
And so for the 10 years that the sewer has been finished, we operate within our budget. We save money to the future. And we also have very few employees. I think that if this Board of Commissioners would like to do something really good for the beaches area, that they should consider forming another water and sewer district to take over the great growth that's coming to Taylor County. Because our district, with our employees and our defined range, is not gonna accommodate all the growth. The growth that's coming from Four Rivers is way more than 20 or 30 units. It's a fact in the last 5 years that we have approved and installed about 100 new customers. So the argument that we turn everybody away is I don't know what that word is, the argument that we turn people away has not been my experience as a member of the board. Thank you for allowing me to speak.
I misspoke the date. I'm sorry, it was 2013 when Deagle Beach started getting hooked up. I said it
Mr.
wrong.
Chairman, if I could, make a statement. I appreciate Mr. Host for bringing that invitation up, and I was invited to, the last Coastal Water and Sewer Districts meeting. And that was after they had declined, their invitation, so I, got word from our counselor to not, singly, attend their meeting. So I did not attend their meeting, and that was the reason for such. I appreciate you bringing that up.
I'm Don Curtis, and my wife Michelle here, and today's our 41st wedding anniversary. And Michelle, 41 years ago, I'd never dreamed we'd spend an anniversary having been at property bride. But that's where I feel I'm at. And I just want to say that I've been on the governing board of the Swanee River Water Management District. It's dealt with every water and sewer board for 14 counties. And I've never encountered and plus I'm a licensed real estate broker, I've never encountered a situation where a subset of a county government could usurp your planning and zoning as well as your comprehensive land use. We do due diligence for folks. And that's where you go, is to the county government, not to a local, while important, an operational board. And this business about all the chain of events, there's been agreements that just superseded some of that stuff earlier.
y'all's legal, agreement with DCA. And so when I bought the property, 140 land use map as far as I went, because I'm in the land business. And the reaction I got when word got out was, a lot of people said, we sure are glad somebody local bought Dr. Hutchins' property. And the second question from locals down at the beaches is, what are you gonna do about Taylor Coastal? I said, what do you mean? Well, they may not let you do anything with your property. I said, well, that's my property rights, I bought it that. And bought it with a full understanding, knowing that I'd have to go through county building permits in the water management district. And I don't have a plan right now, but I can't even take the property. My wife and I own 4 businesses here in the county. And if I wanted to use that property for loan collateral, 140 hookups versus 1, what do you think's gonna happen to that loan collateral? If I wanted to develop it, if I wanted to have one like right up the road at that Sawgrass estate, something like that. And as a property owner, and Commissioner Moody, you understand this, there comes a time when you work hard, play by the rules, buy your property rights, and it's defended in the Constitution of our country that we have property rights. And you're concerned about spending taxpayer money on legal fees. Well, I'm way past you on that. The amount of legal fees, appraisal fees, just to serve my property rights that I'm incurring. It's a real expense. The only recourse a landowner has is to use the Burt Harris Property Rights Act to defend your private property rights. And I knew Burt Harris in the legislature. He was adamant about it. And so that clock is ticking. You made reference indirectly to it. And I can't slow that clock down. That's prescribed in statute. Is that correct?
Yes.
I can't hit a pause button. But what I've learned is since I bought that property at Fish Creek, is a whole lot of people coming to me, just like the locals that said, what are you gonna do about Taylor Coastal Water? What do you mean, what am I gonna do? Because my only experience in it is Steve Hatchie with Big Ben. Very flexible, very accommodating, very customer friendly. So I'm not knocking you guys. I just walked into a situation where I bought a piece of property and understood the county land use plan was the prevailing document. Impression based on the letter I got that you have usurped county's permitting authority. And that causes me a problem, and that puts my property rights. I'm not hiring an engineering firm to consider what to do with the property. Because I can't give them anything definitive to work with. Is it 1 hookup or is it 140 hookups?
I'm fine with the hookups and expanding something, but what's gonna happen when they get past the 50%? And then USDA says, now y'all got to expand your sewer system, where's that money gonna come from?
Well, I just heard several.
I feel that one, that's more on the legal side.
Mr.
Chair. So you were presented to in 2019 by Taylor Coastal. And you were told that when capacity hit 50%, for 3 months, that would trigger a mandatory DEP review, and it would trigger a mandatory plant expansion. And the concern that was raised to you is how the customer is gonna like this if it raises prices. That was one of the questions that at the county administrator's request, I put together a list of proposed questions that the county could send on if they wanted to, that touch on these issues, since I'm well versed. That was one of the questions that was in there. This was sent in. The DEP wastewater guideline analysis on their website tends to indicate something different. It tends to say that when you do your capacity analysis report, that you have to hire, they have to hire a professional engineer to do. They did the last one in 2020. If that engineer certifies that you will meet or exceed capacity within the next 5 years, then your professional engineer is required to submit a statement that says something to the effect, we're going to start initiating working on a plan. If you're within 4 years, we've started drawing the plan. If you're gonna meet or exceed within the next 3 years, you've got to turn over a design plan to DEP in the next 30 days. But 50%, at least in DEP's wastewater guidelines, documentation, which was provided in those questions along with a website link to DEP, there's no 50% trigger for mandatory expansion, which is why the question was formed. They came before you and told you there was. It doesn't appear that's the case, but I don't know everything. And perhaps someone from DEP told them something different. Put it in writing, put it in an email. There's a different set of law, there's a different set of guidelines. That was the whole purpose of that question being there, adopted by you, so that they could be ready to answer that and say, you know what, in fact, there is this separate requirement over here that's not in the wastewater guidelines that says you will be required to expand your plant when you hit 50%. Maybe there is. That was the whole point of meeting number 1 and meeting number 2 is to get some of these things, and now meeting number 3, asking them to come ready to answer it. They're not. So, to answer your question, there may or may not be a 50% mandatory plant expansion trigger, according to DEP's wastewater guidelines that I provided you all the link to in the document, and my lengthy missives, I know they're long, but this is pretty laborious and document intensive stuff. It doesn't look like that is what the case is. So, I hope that helps, but I don't know if there's a mandatory trigger. There's just not one that I found in DEP's self-styled wastewater treatment guidelines.
I have a
Just keep
question.
hearing
Who
that.
wrote the grant for Steinhatchee compared to our coastal? Like Steinhatchee wrote theirs big enough for growth, and ours was not written big enough for us to grow. That's what my question is. Who did that? Did you know that?
That's assuming the interpretation that development is not welcome, or is not able to be had, is a correct interpretation of the loan documents. It's true that there were references in the preconditions, pre-qualifying documents, that said, well, at first, remember, it was if you had septic tanks and this and that. 04, it was amended again. And then Mike Smith said, well, I think that means commercial and everything. And then 08, they removed the 181 platted lots. And then the county, the whole reason that was raised in the first place was from the DCA's concern, and the county settled the problems with DCA. So, your question is premised on the idea that our documents were written where development couldn't be had. Imagine a situation where USDA looked at the engineer, funded it, and said, you can only connect to these people, and somehow you're only ever gonna hit 50% capacity. Does that make sense? Does it make sense that in your mission statement in 06, while you're heavily involved with them, it says be ready for new development? Or that in the 2011 grant agreement, it says be prepared for growth and development? And that was one of, also in the precondition documents. That interpretation doesn't make sense. And I did want to, Mr. Huxford made a good point. In the past couple of years, they've added 100 new customers. Well, if you can't have new development, how in the world did that happen? That's a good question. Because some of those were add-ons that they have now self-reported as being alleged violations of what they think is the wrong move. So, Commissioner Moody, to your 50% mandatory expansion, that's a really good question. Because if that is the truth, and that is what has been being peddled, if that is the truth, then you're on the precipice of right now a mandatory expansion plan. Do you see anybody hiring engineers to draw one out? Sure don't. That's weird, huh? If we're at 48%, especially in a month like July, somebody would have been jumping a while back, but nobody's jumping.
There's gonna be some other people besides the one here that wants to do some development. That shoreline runs pretty close to their property, right by it.
Yeah.
There's gonna be some other people that's gonna step up to the plate. You're gonna have more development than you realize, real quick.
That's not a bad thing, and if you think it is a bad thing, you're the land use planner. You guys can vote to change this density and knock it down if you want to. I'm not sure, but that's your role. That's your role. And so, that may be the case, but the way the DEP guidelines are set up is as things grow, and your capacity gets less, that professional engineer in your capacity analysis reports has to certify in there when you will meet or exceed capacity. And the DEP guidelines already say, if the PE says you'll hit it in 5, you gotta start planning. Hit it in 4, written plans within a certain time frame. Hit it in 3, you better give us written plans in the next 30 days to review. So those things are built in. So let's say that development starts to happen pretty quickly, and we go from having 50% capacity. Granted, in our peak months, we're still at 25% in the winter, but in our peak months, we're at 50, we go to 60, we go to 70. Professional engineer comes in and says, I think about 5 years out from hitting capacity. Then he's required to certify in that report. We're gonna start drawing it up. And then you start drawing up those plans, and you start working on obtaining the funding and things like that, and you do a plan expansion. Great. But if you don't like development, that's your role to change, not theirs. It's not the tail wagging the dog. You guys are the bosses.
Well, getting rid of the board that's there now, they might work in that same direction, Bill, is there a chance that the board would chance that, or the group you are now, would y'all chance going past the 50%?
With 140 units from, Mr. Curtis's property and the 26 that have already been, that were existing and are being redeveloped by the Four Rivers, that's 162, which is approximately, takes us up to maybe 65% capacity when they're all built. Now, there may be a chance, as Mr. Don Curtis mentioned, he may only want to borrow money on that property. And there's a great big chance that the money that sounds good from 140 units may not be there. He's not promising you that. He has not brought a proposal to the Taylor Water and Sewer Board to develop that property other than conceptual brought by his attorney, Mr. Curtis, that's conceptual. Under the rules that were developed by other people, but that this board, that the board I belong to tries to go by, is that you have to bring in a plan if you want anything more than a single-family hookup. If you want a single-family hookup, we research, the staff does, researches whether or not that lot was part of the original plan. If it is, it's no problem. I'm sure that several of these people that have a problem.
You're told that you can't get a grinder at a single,
Ma'am?
sorry, I'm sorry.
There's a chance that the board can develop faster. So we just need twice as many people. We are working right now, which some of the board may not know. We are 3 years into planning for an upgrade to the water system, which is the oldest part of our water wastewater system. We're 3 years into planning. We have to go to grants. We've got a grant to do neighborhood meters, which is, say, a meter for Decoe Beach that'll tell you whether or not you got a big water leak at Decoe Beach, simply, We've got some grants from the Swanee River. But the main development of upgrading the system will include a big enough water tank to hold 100,000 gallons of finished water. Finished water is the water that's ready to drink. It's had chlorine in it, it's had time to mix in. We currently have 2 10,000 gallon tanks. That's an increase of 5 times. The project value to redo to upgrade the water system is over $3 million. We've been 3 years planning for it. We haven't asked for any help from the Board of Commissioners, but we're getting through it. I think that the I think the end of doing the board and eliminating the board, won't be in the best interest of anybody except for our board members.
Good. Dad, if you come.
Don, are you done?
I think I've said enough representing private property owners, and I'll leave the rest to council. Or my wife.
Now, I heard a lot from, what about members of the board now, the Taylor Water Board? Nobody has anything this one?
Sir, I'm a member of the board.
One question, if I could, Mr. Chairman, in respect to the water project, Mr. Hunsford, I'm familiar with that, but my understanding about that project was that it basically was to maintain similar capacity as to what that current system is. That wasn't framed up in the discussion that I had, actually with Mr. December, that the first understanding I had about it was that it was going to be an expansion, but after the conversation that she and I had.
It'll provide more water, yes, more ready water, it will in the future.
There are no expansions of the lines right now because we couldn't afford that as part of the outline of the project. What we're working simply is for an expansion of our existing plant because we don't have the capacity to provide very much water, more than what we already do, because it doesn't have enough contact time with our chlorine in the chambers that we have. So our design is for new wells and a new ground-based holding system. And it will expand greatly our capacity to provide clean, fresh, safe drinking water. It's the lines we're not expanding right now because we really can't afford to. The project was way out of the reach of the district. When we started getting prices, it was in the neighborhood of $11 to $12 million. So we scaled it back and did a threefold program, which will be the water plant itself, neighborhood meters, and automatic read meters. I have an aging workforce, and getting them up and down on the ground to read meters every month is hard on them. And so we're working towards that as part of the project. We did receive a grant. We went to Swanee River about a year ago and presented a proposal to them. We've gone through the Springs and the River grant system both. We were turned down each time. They read about our neighborhood meter project and asked us to come to a meeting. So I and our engineer went to the meeting and we told them, this is what we want to do. We're trying to prevent water loss. They heard us and said, well, unfortunately, we don't fund meter systems. Okay, not a problem. Within 6 months, I got an email from Swanee River saying, we looked at your project, we like the fact that you're saving water, and therefore we are going to give you a $100,000 grant to fund the neighborhood meter project. That's $100,000 that we won't have to include as part of our water improvements project, but will hopefully let us do automatic read meters and still be able to have an affordable project. But the lines themselves cannot be expanded at this time.
In respect to the wastewater and the sewage treatment, you guys don't have any plans as far as expanding capacity?
At this time, no, because we looked at the oldest infrastructure that we have, which is the water system. And if we can't provide water to our customers, it doesn't matter whether we can treat the sewage or not. Because if we can't give them water, there is no sewage. So that's why we went with the water, because it has cost us more, it's aging, we can't provide what we'd like to for our customers. Plus, it does give us a chance for the future. So once we get that in place, and it's been 3 years just getting to the DEP stage right now, that is something the board has talked about several times about the expansion of the wastewater plant. It's not something we can talk in firm terms right now because we're really busy dealing with the water plant right now. And that's what I can tell you. We haven't formally talked about an expansion. No, sir, we have not. But I had been led all along, and I will admit I never did my research. I was told the same thing that all the board members were told and previous office staff was that at 50% we had to expand the plant. That was just something that it was passed down. I did have an email exchange with the design engineer who designed the original system. And he told me that that was a very common misconception amongst water and sewer districts. And that he says, I've heard others think that plant expansions were triggered by percent of capacity. It makes sense that a required expansion is primarily a function of time to reach permitted capacity because not all facilities have increasing flows, especially if their service area is at or near build-out. So he said that he had heard this all the time. So he gave me this information. I got it back from him on the 28th of June. I have not had another board meeting to be able to present this to my board about the expansion, because Mr. Curtis, when he talked about it, I went down and read the DEP information, and I thought, well, this doesn't match what I have been led to believe the whole time I've worked at the district. And there was hardly anything in the files concerning it. So I went and pulled the capacity analysis reports, and I called the engineer. And he got back to me and told me, and he explained the same thing Mr. Curtis had explained to me about the capacity of the plant. And so that, I have not yet had a chance to present it to the board because it came in after the last board meeting, but before the next one. So we did find that out, and that's just, and I will say, I called it institutional knowledge, and he said it's very common that 50% has been thrown out. And people believe that that is the chance, that is when they have to improve, and it is not. So I was confirmed, because I couldn't make sense of it, so I went to the engineers, and that's what, because Mr. Curtis had put this explanation in, and I thought, well, it makes sense here, so let me go and ask the engineer, and that was exactly right, that we are not forced into an expansion at 50%. But it took my engineer a couple weeks to even get back to me on that, to give me a really good explanation that I can give to my board. So that's one of the reasons why, no, they haven't talked about an expansion, because frankly, we don't want to put that expense on to the customers. We have a very small customer base. 70% of our customers are zero to minimum use. And so that does not generate a lot of extra income to the district. It's the money we make on the extra usage that allows us to fund and put away money. The money we get from the 0 to 3,000 gallon users, a lot of that is pledged to pay our debts. So because we're really one of the more unique systems in the state, and I've had several people tell me that, is you guys have a very small customer base, but you have a very large, property-wise, you're very large, but you have a very small customer base. So we've been torn about what can we pass on to our customers and what we can't. And we've been the board has been very judicious in saving money and trying not to spend the customer's money if we can help it, or not raise rates any more than we have already had to do. So I'm not defending anybody. I'm just saying that they have tried to be fiscally responsible. And legal fees are one of them. The past 5 years, our average annual legal fees were between $300 and $400. The past 2 years, they've averaged $12,000 a year. So that's a big increase, and that's a budget item that eventually our customers would have to pay for. And so they try to be very careful and do what they can not to pass increases on to our customers. I'm sorry, I didn't mean that long of an explanation.
Okay. All right. Anyone else?
Mr. Chair, we don't need to waste any more time with this. This board needs to take charge, and we need to move forward. We've got people here waiting, some people that's gonna develop, and as you all know, we're looking at some things that are coming up that have been mandated for this board, and we're thinking about ways that we can increase our revenue. If we've got people that want to develop, that's going to increase our revenue. We've got a $15 an hour mandate coming up. We've all been pulling our hair out. How are we gonna meet that mandate? This current water board has had plenty of time. This is not rushed up decision tonight. If we're trying to wait on USDA, how long have you been waiting already? A year and no response? And how many more years would it take before we get some sort of answer? I think we need to move forward with, we have a motion and we have a second on the floor. I think that the right thing for us to do is to appoint this new board and try to move forward and give these people an opportunity to develop our area.
You need to call for a vote.
I don't want the county commissioner to have to run a water and sewer plant.
We're not doing that.
I hope not.
Mr. Chair, I call for the question. I call for the question.
All right. You go bring the motion, I'll need to bring it. It's been motion and second.
Motion and second. Fairfield County needs to be hooked up to the point where they'd have to run a water and sewer system just because of getting rid of the roof and then this whole thing goes south on them. That's the only reason I'm against it. I would love to see development down, I'd love to see more things go, but I don't want it to end up another job for the county to have to run or be responsible for the cost of the sewer water system. I mean, that's where I'm at, so. It passes.
No, I think we just have to go on with the business of appointing a new board. That's gonna be something that we need to move forward with. And, so,
I could address that for you, if it pleases.
Go ahead.
Presently, Taylor Coastal is already running ads asking for membership applications. I've also been, putting the word out there for, to ask people to consider that would normally want to be on a board, to submit an application. Good minds can get this thing back up and running, that follows your lead, so I am working on that. You'll have applications in hand by your next meeting to make appointments, to fill the board with, okay. The one,
If I may, Lynette, help me recall, what was the deadline to submit applications for the June 22nd meeting?
For the June 22nd meeting.
July 22nd, I'm sorry.
It was last Friday, the 12th of July.
So we have 2 applications in hand, but we prepare our agenda for the next meeting on Wednesday for the next board meeting. The next, right.
what email address do applications need to go to?
As long as I can continue to accept them up until agenda prep, which would be Wednesday at 10 o'clock.
We'll have more than enough candidates ready for you to consider.
So you got 2 applications now,
But it sounds like we'll receive more.
what else coming for this for? Do I hear?
Hey,
Not to speak, but I just understand when they're telling lies about my goals in life, not to spend money on furniture. Get this all set up.